Nandlall in the appeal states that the learned Chief Justice misconstrued and misinterpreted Articles 113, 186 and 1033 of the Constitution in arriving at her decision that the decision to appoint Sarah Brown and Vikash Ramkissoon as Parliamentary Secretaries was unlawful.
I disagree, and I pointed to the Chief Justice the difference in language of the relevant provisions, those that govern the appointment of technocrat ministers and those that govern the appointment of parliamentary secretaries.
Nandlall, who spoke with this newscast via telephone on Wednesday, confirmed that the appeal had been filed electronically, but said he is not yet certain when it will come up for a hearing. The Attorney General asserted that while the Chief Justice is of the opinion that the appointment of parliamentary secretaries follows the same procedure as that of the appointment of technocrat ministers and ministers, he sees it differently.
You have to look at the provisions. In terms of parliamentary secretary, in my view, they can come from non-elected members of the National Assembly or persons who are qualified to be elected, as well as elected members of the National Assembly.
The Attorney General relied on Article 186.1 of the Constitution for his perspective of the matter. Article 186.1 says that, and I quote, "Parliamentary secretaries may be appointed from among persons who are elected members of the National Assembly or are qualified to be elected as such." End quote. On Tuesday, the Chief Justice, as part of her ruling, stated that the two appointed secretaries cannot be both elected and non-elected members at the same time, while also proffering that it would amount to anarchy for her court to not abide by the ruling of a higher court, as a similar matter was adjudicated at the Court of Appeal in 2016, which she also relied on for her ruling. In 2016, the appointment of Keith Scott and Winston Felix as technocrat ministers in the National Assembly was challenged before the then Chief Justice, the late Ian Chang, who ruled that appointment of the pair, who were government ministers at the time, was unlawful, resulting in an appeal also being filed. It is that judgment which the Chief Justice relied on heavily to hand down her ruling on the matter on Tuesday. Madam George further informed the Attorney General that he cannot approbate and reprobate at the same time, since he was the attorney representing the petitioners in that case against Felix and Scott. The Attorney General in response stated that the law is clear on the matter, but opined that the Chief Justice got enmeshed in Justice Chang's ruling instead of the Constitution.
But the learned Chief Justice in my view, got enmeshed in Justice Chang's judgment, and though I attempted to pull her away from it and say that Chang's judgment is not the law is the Constitution, I was unsuccessful.
Wendell Badrie, HGP Nightly News.